Good afternoon, friends. Good night. We're going to have our live with me, attorney, immigration lawyer Alena Shautsova. I'm going to just share with you a quick recap of the most interesting recent immigration news. We're going to discuss Trump's statements in Congress with regard to potential immigration changes that he announced just last night. We're going to talk about USCIS changed policies. And of course, we're going to discuss the fact that mayors of sanctuary cities defended their policies today in Washington, D.C. So thank you very much for watching. If this is your first time here, welcome. My name is Alena Shautsova. I'm immigration attorney from New York. I help people from all 50 states and overseas. And I hold these live sessions regularly to answer your guys' questions and to share the most interesting, important immigration news. So please join me, like and share this show. Ask your questions in comments. Don't be shy. If we have time left, I'm going to be answering your guys' questions live. Thank you very much for joining, and let's start because it's sort of late tonight. So first of all, of course, I wanted to let you know, very importantly, that USCIS these days made it a habit to change certain forms without notice and without what we call a grace period. I'm referring to recent changes with regard to adjustment of status packages, Form I-45, I believe N-400 was changed as well, and Form I-131 as well. What happens is that we open USCIS.gov website, we have the package for the client ready to be mailed, and we discover that now USCIS, as of today, for example, or on March 3rd, does not accept the previous editions of the forms. And I have to tell you, I'm not sure what's going to happen with that at all, because sometimes when we mail the forms, it takes at least 1 day for USCIS to receive the package. So what happened recently was that on a day when people were mailing their forms, the forms were in effect, and the next day, USCIS, without the grace period, stated that every applicant must use new edition of the forms backdated to January 20th that they just published on their website on March 3rd. Typically, when USCIS updates their forms, they say that we updated the form, but for the next 30 days or 60 days, you still may use the previous edition of the form. After a certain date, we will not accept and we will reject the previous edition of the form. So this did not happen this time around. And I guarantee you that there will be cases where you're going to be contacting your attorney saying, why on earth did I receive a rejection of my package? I don't understand. You didn't do your job. But the reality is that the USCIS did it without any notice, and all those forms will have to be probably resubmitted and redone. So it's very annoying, and we'll see what's going to happen. American Immigration Lawyers Association is trying to resolve this issue. We're going to see how effective they will be, but this is, of course, not something that we're used to seeing much. Actually, it never happened before. So guys, I see that we have a good amount of people joining. So remember, once you are ready to mail out your package, on the day of mailing out your package, go to USCIS.gov website and check edition of the forms of the form that you're trying to submit that is in effect. How do you know that? Well, they're going to publish. There is like a special section where the government says, let's say this is Form I-45, edition of the form, and they say edition date January 20th, 2025. So you look at your package and you look at what's written at the very bottom of your form, whether it's the same date or it's a different date. And if it's a different date, you know you have to redo your submission, all right? Because it will be rejected. They're not going to accept it. It's, again, not nice, and some people probably going to really suffer from it, especially those who potentially had a tight deadline. That's why you always want to submit your forms whenever it's possible, at least 30 to 45 days prior to your deadline, not to find yourself in such a situation when your package is rejected and you are left without status. Now, let's talk about the most interesting announcement that was done by President Trump yesterday. Of course, I'm going to be referring to his announcement related to immigration only, and particularly two things that were of interest to me. Well, first of all, and of course to all of you, first of all, he one more time stated his intention to implement the gold card, that mysterious way for someone to receive a green card or residence in the United States by paying $5 million. He mentioned that he's going to be very selective with people who's going to be filing for this gold card, that these going to be the people who will be paying taxes and creating workspaces, employment spots in the United States. And he's very excited about this program. Of course, none of us has seen the details of this program yet, but I'm going to tell you one little thing. So currently we do have investment visas like EB-5, but the problem with EB-5 is that it takes a very long time for it to be processed, but this is not the main obstacle. People may have $1 million to invest, but they struggle proving the origin of this $1 million, because under the current EB-5 rules, you must prove where you received that first penny, that it must be legal. And that's where most people have issues with. Why? Because in certain countries, people avoid paying taxes, or they took the money somehow to a different state, and now they're struggling with this origin chain of custody of the pennies of their dollars, and that creates problem for them. I have a suspicion that this gold card is going to eliminate this trouble, and it will make it easier to qualify for investment route in the United States. Of course, it opens the door to so many questions as to why Russian oligarchs are going to be able to invest. Are we going to accept people who got the money through criminal sources and so on and so forth? But I have a feeling that this innovation aims at, of course, attracting more money for the economy of the United States, and at the same time eliminating what President Trump's administration may see as bureaucracy towards the way of investments and investment immigration in the United States. That's just my guess. We're going to see when the rules are going to be published. We're going to see what qualifications for those gold cards would be. But that's not even the most interesting part of his speech. The most interesting part was that he again mentioned that he didn't give up his plans on giving green cards to students, graduates. And this is very important. Some of you have been asking me these questions, saying, listen, he did promise that students are going to be able, graduates from good schools are going to be able to receive green cards in the United States. And he again mentioned that he doesn't want the talent to be wasted and being sent to other countries if people graduated from universities in the United States. So at least that is a positive in the ocean of negative that we are seeing. That potentially may be one big positive change that his administration may actually bring. Again, do not know any details, what qualifications would be. Would somebody who graduated but overstayed their visa qualify? Do not know anything. But it's a good indication, at least, that the Hill administration did not give up that idea, and potentially they are working towards that idea becoming the reality. Now I wanted to share with you a little update with regard to USCIS interviews For those of you who are filing marriage-based cases during the during the Biden administration, green cards based on marriage mostly were applicants were not called for the interviews. Now you need to know that that changed. If your case managed to end up in a field office prior to Trump's administration taking over, then you have a chance of receiving your green card still without the interview. But if your case was in one of the processing centers by January 20th, most likely you guys will be called for the interview. It means that most likely for newer cases, the interview is a certain, almost certain thing. Of course, we're going to see what's going to happen. New administration has been in office only less than a couple of months, so we're going to see if this theory shared by one of the supervisors at USCIS is in fact, the new practice. And finally, sanctuary cities are under attack. The new administration doesn't want them. They called the mayors of sanctuary cities to testify in Congress, asking them, like, what's up with your policies? How is that you're saying that they're good when we're trying to enforce federal immigration laws? And you know what happened? What happened was that the mayors were so good in articulating and defending the policies that it seems it was a wrong move to bring them and show these congressional hearings live, because they made sense when they argued as to why they have those policies. They basically stated that if you're trying to enforce immigration federal laws against some hardened criminals, we're not in your way. But we also do not want law-abiding, hardworking, tax-paying immigrants to feel unsafe in our cities. And that was the message. So the mayors stood strong. We're going to see what's going to happen, because, of course, we're all waiting for the immigration reform that would give pathways to people who are hardworking people, who are contributors to our society, to give them some sort of a way, even if it takes a long time, to receive that green card, conditional residence, or green card, or even a work permit and a travel permit, right? Something. So this is where we stand with everything. So there is a lot going on right now. Every day there is a new policy. There is something new published. If you have questions about anything that you've heard, please let me know. And now I'm going to be answering your guys' questions. Thank you very much for sharing this live. Thank you for your questions. If you guys watching me on TikTok, thank you very much, Miriam, for your flowers, for the gifts. And let's start. Let's start with your questions. Can you explain about withholding case or CAT? Sure. So withholding removal or Convention Against Torture Relief can be filed only if you are in immigration court removal proceedings. The threshold to prove the case is higher than for asylum, but it can save somebody from being physically deported to their home country if there are good reasons for hold off on that deportation. For withholding or removal, you need to show that you're going to be persecuted in your home country based on a protected ground related to asylum. For CAT, there are two different CAT reliefs, actually. You have to show that more likely than not, 51% likelihood of you being tortured in your home country, not necessarily related to protected ground. So for CAT, there are no, I call it CAT, there are no bars. You just need to show qualifications. For withholding or removal, you may be disqualified based on criminal convictions from withholding or removal. So it's kind of complicated. It's very legalized, like it's basically based on the law more than facts, your qualifications for these reliefs. But what happens if the judge grants it, that there is an order of removal issued against you, but at the same time, the judge makes an order not for you to be deported, all right? So for you to lose this protection, something has to happen usually. Either conditions in your country must improve tremendously, or maybe you did something that disqualified you from withholding, and the government caught up on that. So that's what it is. All right. The bad thing about withholding or CAT is that they don't lead to a green card. You won't be able to get a green card, right? Hey, Miriam, should I be concerned if my oath ceremony was canceled for Foreman 400? When was it scheduled for? If it was scheduled for January 9th, that's totally normal that it was canceled, because suddenly it became a national holiday, and all those USCIS hearings and oath ceremonies were rescheduled. Sometimes it happens that the ceremony is rescheduled. Usually it does not concern your facts. It's like it's not related to you. It relates to something else. Unless, of course, something happened and USA has decided to do a deeper background check. A kind soul wrote something to USCIS about you. For that reason, I say never share anything related to your case, even with your friends. Don't discuss it, but don't. Because people can get jealous of nothing, of nobody, nothing, and they can like try to mess with you. But usually, rescheduling of the oath ceremony is not a big deal, all right? We also need to know how long you've been waiting for the new date. Has it been like a couple of weeks? Are we talking about a couple of years? So, all right, all right. Are they still firing judges? I have not heard of new fires, I guess, of the judges. I know that some judges who worked in Chicago court were terminated. But, and it's strange because Chicago court is kind of slow to begin with. Now with less judges, they're going to be even slower. But I have not heard of any massive firing of the judges. If you've heard something, please let me know. Hi, Ahmad. Can I apply for a refugee travel document from outside of the United States? No. What happened? Why are you outside of the United States without that document? It's possible sometimes to return to the United States, but usually not with a refugee travel document if you left the United States without it. But first you have to have the refugee or asylee status. Did you go outside of the United States and your document expired? Or you left, you never applied for it? That's not a good idea, guys. Remember that this administration is extremely strict. You have to have plans for travel document, re-entry permit, advance parole prior to leaving the United States. Okay. Hi, Pollock. My friend received. Let me show the question. Thank you very much, Miriam. My friend received his secondary fee request for his I-45 form. Question, what did it mean? He won asylum. Well, we would need to know what the USCIS is asking in the secondary fee, in the second request for more evidence. What is it that they're interested in? What is it digging? Are there any discrepancies? Did he incorrectly answered questions on Form I-45 and his answers do not match his Form I-589? That's one of the most common mistakes. On the Form I-589, you typically answer questions related to your membership in various organizations, or a question about have you ever been arrested or detained? And you say, oh, yes, I'm a member. Oh, yes, I've been detained. Time passes. You received your asylum. You filed that Form I-45. And you started answering no for all the questions. That's a huge mistake, all right? And some people believe that, well, but my asylum case is confidential and I don't really want to share previous lives information, but that's not how it works, okay? For the federal government, that asylum case is not confidential and they will have access, especially if we talk about immigration, to your Form I-589, and they will compare the answers. So if you made a mistake, if you forgot about memberships, you will have to explain what happened. And sometimes I've seen RFEs that were mistakenly accusing a person of not mentioning membership in organizations. When the person said, well, wait a second, I did disclose on all the forms the same information. Why are you asking me to explain myself? And that happens. It's okay. Then you submit a copy of what you sent to immigration twice, and that resolves it. All right. But we need to know what is it that they're asking, because without that, I cannot really tell you anything meaningful. Thank you, Kylo. See, are they still firing judges? Yes, we discussed that. Hi, Mr. Motu. Today, 4 months completed. The word GPS on my foot, that you were wearing GPS on your foot, but still did not remove. Why? Then they decided they don't want to remove it. What happens is that you have to ask your deportation officer, your ICE officer, to remove the GPS device. And then they will make a decision whether or not they want to do it. If you have certain health concerns, issues as to why you don't want to have it or you cannot have it, let's say it causes migraines, right? And you have to take medication because of that, then you should share that with the officer. I'm going to tell you, GPS device is still better than detention. Just remember that, please. Could you please explain about the family petition from citizens to parents? Hi, tumbleweed. All right, so I-130 form can be filed by a U.S. citizen child who is 21 years old for their parent. If the parent is overseas, they will have to go for the visa in the United States consulate in the country where they reside. If the parent is in the United States, the parent may be able to file for adjustment of status, provided that they're not inadmissible, that they have a legal entry, they do not have an order of removal against them, they do not have certain disqualifying criminal convictions. Typically, these are the issues, right? Let me see. Hi, funny. Enter the United States via Tijuana Customs, showing my Mexican passport, and I was waved in. Is it a legal entry? Well, it may be, but in certain states and certain USCIS jurisdictions, they do not accept it as a proof of legal entry. I've heard that in California they do, provided that you can bring affidavits from at least 2 people confirming the manner of entry. Why don't you consult with a local attorney from California and see if this is the case, okay? It went from status will be scheduled to oath ceremony was canceled. Hi, Miriam. I wouldn't worry about that, too much. I think you'll be fine. I think you'll be all right. Filed I-212 waiver, 2 years, no reply. That's typical. 5-year bar over, expedited removal outside the United States, married to U.S. citizen. All right, so you served your bar already. Well, your waiver was pending, right? Then you don't need a waiver anymore. Why don't you contact the consulate and say, hey, listen, my bar expired. I would like you to issue a visa. So what they will do, they're going to tell you what is it that you need to do so that they can issue the visa. Usually you'll have to appear for the interview again and have a new medical. And they probably would want you to resubmit your fingerprints. Very important. All right. Yes, I left the United States because of a family emergency and couldn't take my travel document. Got it. So why don't you contact the United States consulate and see if they would be willing to give you a boarding foil, for example. All right. But there are so many questions here. I think you should speak and work with an attorney prior to doing that. What document did you use and where did you actually go? Did you go to the country from which you asked for asylum? And did you use that country's passport to travel? So you may really face some issues in that case, okay? You really have to work with a lawyer in this situation. I'm sorry to hear about the family emergency. I hope things resolved well. Hi, why? I'm overstaying my visa and worried about flying domestically for work. I've been using my foreign passport for TSA check. Could this trigger an immigration status check after this May? Yes, it will. Why? Because if Real ID will become real this time around, remember that it's been postponed for like 20 years. If it will become real this time around, will be the fact the airlines are not going to allow you to board the plane without seeing that real ID confirming that you do have immigration status or some sort of authorization to remain in the United States. And will they trigger? I do not know how cooperative they will be with the CBP, but I would not rule that out. Okay, that they will be cooperative. So it's a tough situation. What can I say? I know that it seems that airlines don't really want that real ID to kick in because they're going to lose customers. All right, they're going to lose customers, but we'll see. Hi, IK. Cancellation of removal was terminated without prejudice because of a mistake in notice to appear. Is it anything that can be done to be protected from deportation? No, no, it's really not, unfortunately. So, what happens is that the old case was closed because the government made some sort of a mistake. It doesn't mean that you gain status because of that. So if you don't have lawful status, the government may, in their discretion, file a new case against you. Okay? All they need to do is just to refile the case. Hi, Jean. So Jean is asking about delays in receipts from USCIS. Guys, I see delays in receiving receipts from USCIS for all kind of applications, be it DACA, be it VAWA, be it TPS. All of a sudden, it takes much longer to receive the receipt. I don't know why. Maybe they got fired too. I have no idea. I really don't. And I'm telling you, it's very interesting. I also saw some interesting rejections for that they didn't like the signatures on the forms all of a sudden. Something is cooking there, but I really do not know why. What's really happening? So, do you need to worry about this? Typically, if your form is duly signed, if it's signed correctly, and you can see the signature. That's why I say always sign in black ink, because if somebody has to reprint your signature, it will be visible, opposed to blue ink, which fades with every time you have to scan and print the document. If you paid the correct amount of government fees, you dated your form, and the form had the right edition date, then you don't need to worry about the rejection. Okay? So it's only if you have a signature issue, date issue, incorrect fee issue, and incorrect edition. These are the most common reasons why USCIS would kick your submission back, saying you have to correct something in your submission. And usually it's not a big deal. You can just resubmit it back and you won't really suffer any negative consequences. Just keep evidence that you did comply with the deadline, but your form was rejected, right? Unless, of course, we talk about adjustment of status and some holes in your status, then it becomes a totally different game, all right? RK, do you think the government should pass a law that every 25 to 30 years the registry should be updated. If this much time has passed and the government wasn't able to deport an individual, they should. Well, there is a proposal to make this registry law on a rolling basis, so-called every 7 years. If you manage to hang on to your residence in the United States without being deported for 7 years, you should be able to file for something, provided you're a good person, you don't have criminal charges or convictions, and you've been paying your taxes. Every 25 years, like a little bit long, I think 10 years would be good, okay? All they need to do is to allow people who currently may file for cancellation or removal only with the court to file it affirmatively with USCIS. And in certain situations, like people who qualified for TPS, they should shorten this period of time from 10 years to, let's say, 5 or something like that. So that's what they should do, really. It's very simple. It's like registry on a 7-year period. Okay, they can make it 10. Why 10? I don't know, but 10 just sounds like you're more deserving, just because we're already used to this number, because we have like 10-year cancellation removal. Remember, when they were trying to pass parole in place, they also used 10-year mark, right? So, and another part of the law, they have to change qualifications. They have to change the standard. Instead of asking for exceptional and unusual hardship to a U.S. relative, you should be able to show hardship to yourself, all right? Number one, because some people are single. They've been here all this time. They're good people, but they don't have family members because they're just single. Yet they've been paying taxes, contributing. They've been very often they're running businesses, so they should be able to benefit sort of from something as well, especially if they've been contributing to social security system. When they get older, they can't even take anything from that social security system. So it's kind of like unfair, I say. So this has to be fixed. We should have a fair society. I'm not saying that it's okay 100% for anybody who violates the law or immigration law to stay, but sometimes life happens, and that's just the reality of it, okay? People that I speak to, my clients, usually they say, well, I didn't plan to overstay here, it just happened this way. Either I was sick when I got pregnant, I got married, I got divorced, something happened, and that's just how it happens in most situations. And then the people get stuck here. They live here sometimes for 25, 30 years, and they don't have status. So this has to be fixed. And these people don't really ask anything for free. First of all, they've already been contributing and paying taxes. And second, they're more than willing to pay a fine. Okay? Everybody I speak to, is like, of course, if there is an opportunity for us to pay a fine, we will do that. If it opens pathways, however long, to become legal, all right? So 25 is kind of long, I would say. They should really settle on something like 10. I feel like if you put 7, something shorter than 10, people will object and will say, oh, you can't just, that's too short. But 10 years sounds like, a decent amount of years, all right? All right, so let me answer a couple more questions tonight. Let's see. Hi, Ahmad. Okay, you failed. Yes. Yes, there is so much information. Is it true that Trump signed an executive order to abolish marriage green card? I have not heard of that. And that cannot be changed by Trump's executive order. That's in the law. Executive order cannot beat that. You have to have an act of Congress. Okay. Filed I-212 waiver 2 years. Okay, we discussed that. Waivers do take a very long time. Just for general information, guys, it takes years, sometimes up to 4 years, right? Hi to my trans LLC. I won my asylum last year, and to send my I-45, do I need to file with a new edition of the form? Of course. Absolutely. You must to comply with the new edition of the form I-45. How else you can do? Because they look at the edition of the form, not when you win the asylum is when you submit the case. That's when, on the date of the submission, the form has to be valid. Okay. Let's see. What the new NTA memo means for naturalization cases that were inadmissible at the time of the adjustment. That sucks if they were inadmissible at the time of the adjustment. We discussed, I have a video on my YouTube channel about the new USCIS memo. And it's not that it's something new, but they just pretty much put it in writing that if during naturalization process, USCIS officer discovers that you received your green card in error, they will place you in removal proceedings. Sometimes, regardless of what you think, it's a blessing because in certain situations, it's possible to correct that error only when you are in removal proceedings. So sometimes it's not the end of the world. Sometimes it's going to be a problem. Okay. So that's why when you work with a lawyer, they have to check how you received the green card to begin with. Did you qualify for it? Common mistakes. A person stated that they were not married and received an immigrant visa as unmarried child of a permanent resident. But prior to entering the United States on that visa, they got married. I have no idea why people do that. They do it all the time. Guess what? They disqualified themselves from this category of green cards, but they did not disclose at the border that they got married and they received the green card. They lived here for a while and then decided to sponsor their spouse. Filed I-130, disclosing the date of marriage. And then it becomes obvious that they shouldn't have been issued that green card. Or a person like that files an 400 form and fills out the forms correctly, talks about the date of their marriage, and it becomes obvious that they didn't qualify for the green card. Or, for example, a person was in employment, immigration, and the visa number was not available when it was issued, when the green card was issued to the person. Person loses the green card status and going to be placed in removal proceedings. Or there are some criminal convictions that make the person deportable. Things like that happen. You don't want them to happen to you. Try to minimize the errors. Try to address them as soon as you can. Try to make sure if you see that the government issued the green card to you without asking for the waiver when they were supposed to ask you for the waiver, don't think you got lucky. No, you will have to work with an attorney to try to address it as soon as possible. Reopen that I-45, submit for the waiver, rather than thinking that, I got lucky. Because sooner or later, they're going to catch up on the error, and that's going to be devastating. Sometimes they catch up on the error after you become a citizen. Believe it or not, they can still denaturalize you. It's a complete mess. Do you do bonds, and where are you located? I don't provide bonds, but if you're referring to bond hearings, yes, I do handle hearings when we ask the judge to release somebody on the bond. All right, let me see more questions. And how are you guys doing this night? Where are you watching from? I mean, in New York, it's already 9:35, sort of late. And what about you all? Where you guys are watching from? Is it late there too? Hi, Jean-Pierre. Should I reapply or should I wait for the receipt letter? Hi, Jean. I would not be able to advise you as to what you need to do. Why don't you speak with your attorney, okay? Why don't you review the package that you submitted to see if there were any potential errors? If there were no errors, then you should be all right, I guess, unless you have some sort of a deadline, which only you probably and your lawyer are going to know about. Then you you may have to refile the package, but see what's happening with that, okay? Hi, Brett Baker. Will I-601A waiver processing times continue to get faster? I do not know. I really do not know. We do not know. Some lawyers believe that USCIS is going to work slower due to the fact that they will be calling everybody for the interviews. Of course, I-601As were never called for the interviews, well, until now. But it's hard for me to predict as to what's going to happen. It depends on many different factors. How many offices they have available, how the office is going to be working, in office, out of office, what are the issues they will have to deal with, right? It's just a lot to take in. Right now, everything is very fresh. I would say that we're going to have a better understanding of approximate speed with which USCIS is going to be processing cases in a couple of months once things are going to be more settled. All right. Hi, Ian. If somebody was arrested but never convicted, can they get a green card? Well, maybe. If they were arrested but never convicted, what happened? Were the charges dismissed? Then most likely yes, unless the person is going to admit to the fact that they committed a crime but didn't get punished for the crime. And if the crime is making a person inadmissible or deportable, then they will not be able to get a green card. Inadmissible, not deportable. There are just a little handful of certain offenses that make a person inadmissible but not deportable, like domestic violence, for example. So somebody with domestic violence can receive a green card, but if a green card holder is accused of domestic violence, they can be deported. And there are more crimes like that. It's very interesting how the United States immigration law works. However, you also need to know that certain lawmakers want to close out that loophole related to domestic violence and make everybody inadmissible. So that's what's happening. There are some other unpleasant changes that may come, but we'll see what's going to happen. Democrats finally started fighting back. I feel like they were in shock for the first months and didn't do anything to, let's say, counter the Lake and Raleigh Act, even though it creates a messy situation for immigrants because it's just so, how to say, it's not well integrated with what we are working with right now. It's just not it doesn't work together with other laws, immigration laws in the system. All right, guys, so thank you very much for watching. Thank you very much for your questions for tonight. I hope that we're going to see each other again on Friday night. If you wish to do so, please sign up for my channels, follow me on TikTok. And of course, I hope for more positive news than negative news. We're going to see what's going to happen. Every single day now, something is happening. I hope that Trump's administration is going to also focus on green cards for students, for example, and maybe even potentially on green cards for DACA and certain TPS holders, dreamers, as they promised, and maybe even registry. We're going to see. Negative, you know that policies become stricter and stricter. You have to make your case very strong before you are submitting it. Prepare it very well. If you're submitting it before USCIS and immigration courts, you have to submit your documents nowadays at least 30 days in advance of your hearing. Very important. Change deadline. And overall, just try to be prepared more than being scared. Okay, thank you very much for watching, and I hope to see you soon.